Courts have ruled that U.S. presidents are immune in civil cases for what they did in office, meaning they can't be sued. But can they be charged with a crime? That's a question that has never been tested. Now an appellate court has weighed in and decided unanimously former President Donald Trump is not immune. And he can be tried for his alleged crimes on January 6th. This after Trump's lawyers tried to set a new standard in court, which seemed to baffle the judge.
This just happened, and it is a huge hit for Trump. The Supreme Court turned down his emergency request in a short 5-4 decision. There was no full hearing, no spoken arguments in court, and no big dramatic courtroom moment. The message was very clear. The sentencing process could continue. Even one judge that Trump personally chose joined the other side and voted against him. Going to prison was not suddenly certain, but the legal risk became much more serious. In the middle of this huge political storm is the New York hush money case, where Trump was found guilty on all 34 felony charges for changing business records.
President Donald Trump found guilty of all 34 counts of falsifying business records, marking the first time a former president has been convicted of a crime.
This was a rigged, disgraceful trial.
Manhattan District Attorney Alvin Bragg brought the criminal charges against Trump.
I did my job. Our job is to follow the facts and the law without fear.
This case had already become a part of history long before the Supreme Court got involved. For the first time ever, a group of regular American citizens on a jury found a former president guilty of serious felony crimes. The prosecutors supported their case with documents, people giving testimony, and a detailed money trail that went directly into Trump's close circle. Their argument was simple but very powerful. They said that damaging information was hidden from voters during the 2016 election because of a payment connected to an adult film actress, and then that payment was covered up through carefully hidden reimbursements and false business records.
Pat expressed his admiration for the vice president's actions on the day of the 6th and said that he concurred with the legal analysis that our team had put together to reach that point.
It made no sense to me that in all the protections that were built into the Constitution for a president to get elected and steps that had to be taken, that the power to choose the next president would be sitting with the vice president.
The jury then came back with a decision that shocked the political world, finding him guilty on every charge. But in America's complicated legal system, a conviction usually does not mean the battle is over. Instead, it starts a whole new stage filled with appeals, legal fights, and strong attempts to reverse the decision. Trump's lawyers acted right away, filing requests to cancel the verdict and looking for any legal reason that could stop the conviction from remaining in place.
Today, there is more fallout from Monday's Supreme Court decision involving former President Donald Trump. The court ruling that presidents have immunity from prosecution, but only for official acts. Skylar Henry reports.
Former President Donald Trump's legal team is asking for his criminal conviction in the New York hush money case to be overturned, citing the Supreme Court's landmark decision on presidential immunity for official acts.
There were a few checks signed when he was president, but I think it would be really, really hard to say that those were in either category of official act, and those were just, were just unofficial personal.
They argued that the trial was completely unfair, the judge had a bias against him, and the case was pushed forward because of politics. But none of those arguments succeeded. So, Trump's lawyers took the fight to a higher level, going to the appeals courts and saying that presidential immunity should protect him from evidence connected to his time as president. That argument failed too. As their choices became fewer, they turned to the Supreme Court, the highest place to settle constitutional fights. There, they submitted an emergency request asking the justices to pause the sentencing process while they continued trying to overturn the conviction based on immunity claims.
Trump is working to have his felony hush money conviction in New York thrown out after yesterday's landmark ruling by the Supreme Court. In a letter to the judge described by sources to ABC News, Trump's legal team argues during the trial, the jury was presented evidence that they believe should have been protected under presidential immunity. The defense is asking for Trump's sentencing on July 11th to be delayed so they can have more time to make their argument. The appeal coming hours after yesterday's landmark decision ruling presidents have immunity for acts within their core constitution.
The emergency request was written with a clear sense of urgency, warning that serious and lasting damage could happen and showing Trump as a former president facing an unusual legal attack. His lawyers asked the justices to step in before sentencing and stop what they called an unheard of constitutional harm. The Supreme Court looked at the request, reviewed the arguments, and decided not to stop the process. The message was very clear. Presidential immunity is not a forever escape from being held responsible for crimes. It does not automatically remove actions that are not connected to official presidential duties, and it does not turn every state criminal case into a major federal constitutional emergency that needs immediate action. By rejecting the request, the justices supported a basic idea that should matter in any democracy. The president has great power, but that power does not put one person forever above the law.
Is there a way to remove a Supreme Court justice from the bench? Our sources for this are University of Maryland Law School professor Dr. Mark Graber and the United States Constitution. Article 2, Section 4 of the Constitution states that the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors.
This includes a Supreme Court justice.
Dr. Graber is a constitutional law expert. He says the process to remove a justice from the bench is the same as any impeachment.
The main idea behind this moment is actually very simple. The law does not vanish when political power changes. A former president can still have huge influence, a worldwide platform, and millions of loyal supporters, but none of that automatically puts him outside the reach of the courts. That is why the Supreme Court's decision not to stop the sentencing process in Donald Trump's New York criminal case was so important. It did not end every possible appeal, answer every constitutional question, or mean that Trump would definitely go to prison, but it did send a clear message. Being a former president could not automatically protect him from the results of a jury's decision. For years, delay had been one of Trump's strongest legal tools. His lawyers challenged court decisions, asked for delays, filed emergency requests, and appealed almost every major ruling that went against them. The goal was not always to win the final fight right away. Sometimes, the goal was simply to slow things down long enough for an election, a political change, or a new situation to change the entire legal battle. Trump's lawyers repeatedly argued that putting a former president on trial created never-before-seen constitutional problems. They said his position made him different from any normal person facing criminal charges. But in the New York case, that approach eventually hit a barrier. A Manhattan jury had already found Trump guilty on all 34 felony charges of falsifying business records. His legal team then tried to delay the sentencing while they continued fighting the conviction using presidential immunity arguments. They took their emergency request all the way to the Supreme Court, hoping the justices would step in and stop the state court process. The court refused. That decision did not mean Trump had lost every possible appeal left. It did not mean every legal argument from his side had been completely rejected forever. What it meant was that the Supreme Court would not block the New York court from moving ahead with the sentencing process. From a legal point of view, that difference matters. But from a political point of view, the effect was still huge. Trump could no longer act as if the verdict was stuck in some unclear legal space where nothing could happen. The conviction stayed active. The state court was allowed to continue, and the country had to face a reality that once seemed almost impossible. A former American president had been convicted of felony crimes by a jury made up of regular citizens. The focus then moved to Judge Juan Merchan and the question of what punishment Trump would receive. Because the crimes were not violent and because Trump had no previous criminal conviction before this case, many legal experts expected a lighter sentence. There were also unusual challenges involved with the idea of putting a former president in prison while he receives lifetime Secret Service protection. Because of these reasons, a sentence called an unconditional discharge became a possible result. Under that type of sentence, Trump would not spend time in jail, would not be placed on probation, and would not have to pay an extra criminal fine. But the conviction itself would still remain on his record. To some people, that could feel disappointing. After months of intense news coverage and guesses about what might happen, there would be no scene of Trump being immediately taken away in handcuffs. But avoiding prison would not remove the historic importance of the case. The main fact would stay the same. Donald Trump had been found guilty on 34 felony charges. That fact alone carries major political importance, even without a prison sentence. Trump's strongest supporters will continue saying the case was political, unfair, and part of a larger attack against him. Many of them will see the conviction not as evidence of a crime, but as proof that the political system is using the courts against him. But elections are usually not decided only by the strongest supporters of either side. They are often decided by people in the middle, including independent voters, moderate Republicans, suburban families, and people who are tired of years of legal fights and political conflict. For those voters, the words convicted felon may be much harder to ignore. That phrase will likely appear in campaign ads. It will come up in debates. It will be repeated in interviews and political discussions. Every conversation about Trump's decisions, character, and ability to serve in office will now happen while this criminal conviction remains in the background. Trump can criticize the prosecutor. He can criticize the judge. He can attack the witnesses, criticize the city where the trial happened, and say the entire system was unfair. But simply repeating those claims cannot erase the jury's decision. Still, the larger legal situation is much more complicated than saying one Supreme Court decision suddenly destroyed all of Trump's defenses in every other case. Every criminal case has its own charges, evidence, the history of the legal process, and different constitutional questions. The federal election case involved serious questions about the difference between actions a president takes while doing the job and actions done as a private person or as part of politics. The classified documents case involved separate fights about national security information, blocking investigations, and the power of prosecutors. The Georgia election case was based on state laws and had issues completely different from the New York case. The Supreme Court's decision not to delay the sentencing did not automatically decide the outcome of any of those other cases. But the decision did support a bigger idea that Trump and his supporters have pushed back against for years. Former presidents do not have unlimited and permanent protection from criminal responsibility. Some actions taken as part of official presidential duties may have legal protection, but personal actions do not automatically become protected just because the person later became president or once sat in the White House. That idea is much bigger than just Donald Trump. The presidency is a temporary position of public power, not a lifetime pass into a special legal category. A former president leaves office with a place in history, political influence, and government security protection. But he does not leave with a permanent permission slip to ignore criminal laws, and that is why this moment is so important for American institutions. American democracy depends on two important ideas working together. First, prosecutors should never use criminal law as a weapon just to hurt political opponents. Second, having political power should never become a way to escape a real criminal case. A working legal system must protect both of these ideas. It must demand strong evidence, fair rules, neutral judges, real chances to appeal, and proof beyond a reasonable doubt. But when those standards are met, the system must also be able to hold even the most powerful person responsible. Trump's own reaction to this situation is also important. His political image has always been built around strength, winning, and the belief that no institution can truly stop him. Every investigation became a way to collect support and raise money. Every criminal charge became another campaign message. Every court appearance became a political show. Every legal loss was presented as proof that his opponents were afraid of him. But a jury verdict is harder to turn into just another performance. It is an official decision made by citizens after listening to evidence and following courtroom rules. Appeals can challenge the decision. Higher courts can review claims of legal mistakes. But unless that verdict is changed or removed, the conviction remains. This creates a very difficult situation for Trump's lawyers. They have to protect real legal arguments for appeals while also dealing with a client who often attacks judges, prosecutors, witnesses, and sometimes even people on his own legal team in public. Every emotional statement can create more political problems or make the legal strategy harder. And as the number of legal options becomes smaller, the pressure to replace careful legal arguments with public anger becomes even stronger. For Americans watching this situation, the biggest question is not whether someone likes Trump or dislikes him. The real question is whether the same basic legal system still applies when the person being charged is rich, famous, politically powerful, and supported by millions of people. Equal justice does not mean every person receives the exact same punishment. It means a person's power and status alone cannot remove them from the legal process. The Supreme Court's refusal to stop the sentencing did not mean Trump would definitely go to prison. It did not end every appeal or solve every legal fight still happening. But it did stop his former position as president from automatically blocking a state criminal decision. The conviction stayed in place, the sentencing process continued, and the political effects became permanently connected to the legal record. That is the true importance of this moment. It is not about saying prison is guaranteed, but about something deeper and longer lasting. It shows that even a former president can be investigated, put on trial, found guilty, sentenced, and forced to use the same appeal system that applies to every other citizen. Donald Trump built his political image around the idea that he could not be touched. The New York case showed that, at least inside one American courtroom, a jury was willing to hold him accountable, and the Supreme Court chose not to stop the legal process from continuing.